Hello, and welcome to today's session for Legal Futures, Tackling Tricky Issues in Commercial Leases, Part 1. I'm Sarah Thompson-Copsey, and I'm running today's session. This is Part 1, as the title slide shows you, of a two-part session. The second part will be run by my colleague Peter Dollar, and in that session she'll be looking at guarantees, open market rent review. We're looking at a rent review case at the very end of today's session, but it's actually an indexed rent review. And she's also going to be looking at insurance and tricky issues around insurance, always, I know, a very difficult area to look at with commercial leases. So she'll be dealing with those, and that will be out later this month. For our session, however, in the part 1 of this, we're going to be looking at tenant break options. And we're only going to be looking at some things because these are the tricky issues, I think, around tenant break options, around service charges. So we're going to be looking at who the tenant actually is when it comes to tenant break options. And then we're going to be looking at conditions, only conditions with regard to rent and vacant possession, because I'm hoping that nobody has that all-encompassing all other covenants condition. And we'll be looking at both timing, becoming increasingly tricky, and compliance, and of course the recent Court of Appeal decision in the capital case. We'll also then be looking at tricky issues around service charges, and I wanted to look at sort of 3 main areas around service charges, largely to do with commercial leases. But when it comes to proportions, we'll be looking at the juxtaposition, the contrast, if you like, between commercial leases and residential leases. Really important to understand if you're dealing with a mixed-use building. So we'll be looking at the interpretation of the service charge provisions and the court's current approach to that. We'll be looking at certification and why that's so important, and again, the court's approach to the drafting of certification provisions and how the court is again and again going back to that service charge decision of 2015, Arnold against Britain. And as I say, we'll finish off by looking at proportions. And then we'll be looking at, well, what I've euphemistically called recent developments. But I want to look at 3 cases in particular. One concerning relief from forfeiture, which I think is a tricky area. And it's a case that sort of, in a way, caught me out, if you like, and looking at the need for expedition when it comes to relief from forfeiture. Now, I appreciate that for many commercial leases, the last thing the landlord wants to do is forfeit the lease. But where the landlord does want to forfeit the lease, and of course there are still some hotspots around the country, depending on the type of commercial lease you're looking at. So retail, maybe not a hotspot, but logistics, warehousing, most definitely a hotspot. So knowing about relief from forfeiture and why you would choose one type of forfeiture over another can be really helpful.